Good afternoon. This is Chuck Boyd from the Maryland Department of Planning. I am hoping to, I think, Joe, if you can give me a thumbs up in the webcam that you're hearing me. Good. Um, and again, for our virtual audience, please forgive our technical difficulties. This is technically, it's our third hybrid meeting, but each one of these we've added a little bit of enhanced quality, and that adds complications. So again, forgive us for being a little late starting here, just a couple minutes late. But welcome to the Maryland Department of Planning and the MPCA Planning Commissioner Board of Appeals Educational Training course. Again, my name is Chuck Boyd. This is a in-person in Ocean City, and so the people in Ocean City at MML conference, I want to welcome you and thank you for your participation and your service. And for those that are online right now, I see that we have 22 participants online. Again, I want to thank you for your time. We have, and again, for the folks in Ocean City, I apologize. As I said, this is, we're still getting things worked out here. We didn't print out the agenda for you. So this is scheduled to go to approximately 4 o'clock, even though it may indicate that it was longer than that. So we're scheduled to 4 o'clock. And with respect to the folks that are online, there are 2 handouts that are available for you to download and to have access to. One is the agenda, and the second is the PowerPoint. We will send you all the PowerPoint presentation at the end of the session. When we have, we'll send you also a frameable award or a certificate of completion, and we will include a link to the PowerPoint. So feel free to take notes, but don't be worried about copious notes because we will in fact provide these for you. One more housekeeping thing to be aware of regarding the PowerPoint or our presentation today. We are assuming all the people that in Ocean City, if you've signed up, you're going to stay to the bitter end, and hopefully it'll be enjoyable. Those folks that are online, we ask that you stay with us as long as you can, but just be forewarned. I hate to say it, we know who you are and you're signed in. And so if you leave when you're less than 2 hours into the training, we will assume that you want to do this again and will not receive credit for having attended. So this is slated for at least, it'll probably go close to the 3 full hours. So please bear with us. I think we'll try to make it as engaging and enjoyable as possible. Again, I want to welcome everyone. And I just want to make sure that in terms of and I think there's the next taping is a housekeeping slide. So I just want to say, folks, again, thank you very much. This is a training for all planning commissioners and Board of Appeals. So this is really a requirement of the land use article for new commissioners or Board of Appeals members that have just been appointed. Within the first 6 months, you're asked to take this training, and it doesn't have to be this training. We actually have an online training, and we welcome you to take that as well. If you particularly want to get more in depth, it gets much more in depth. This is applicable to municipalities, non-charter, charter counties, and including Prince George's and Montgomery County. Next slide. Again, as I said, we have an online course that's available. It's a little dated now, but we're going to be working on updating it. But feel free to contact Joe Griffiths, who's in the audience, Keith Lackey is also there, or myself, and I'm Chuck Boyd at maryland.gov. We're more than happy to assist you. You have regional planners in each of your areas, and if you don't know, we'll be glad to point that person out to you, and we're more than happy to assist your local jurisdiction. Next slide. So again, thank you for your service. We really appreciate it, and hopefully that you will get something new out of this. Next slide. Today's speakers, Joe Griffith, Adam Snyder is our MDP's counsel, and then myself will be presenting the different ones. I didn't see a slide that I wanted to highlight. So for those people in the virtual audience, please note that there is a questions box, that if you have questions at any time, that please feel free to ask your questions, and want to let you know that we're tracking who's attending, and we will capture your questions. We'll try to answer everyone as we can, and if we aren't able to answer it, we will follow up with you individually. We have recorded your email addresses, so we're good to go, and you will receive your certificate from us when you do complete the course on that front. So again, without further ado, I'm going to turn it over to Joe Griffiths at this point, and he's going to go through the foundations of planning. Welcome, Joe.
Thank you, Chuck. I'm going to do a quick sound check here. It's a little loud. As you can probably tell, we're not really sound folks. We do our best. I'm a planner, but came down here and mixers and cameras. So I've been here for a while, so there undoubtedly is going to be some more technical issues. There have already been some, so I'll do my best. I appreciate your patience because we also have people on the line. I am going to turn off, see, I'm dealing with this up here. Kind of hard to see. I think that's a camera. I'm going to turn off the camera while we're doing, there we go, and I'm going to make this smaller. There we go. All right, that was successful. All right, well, thank you. That was Chuck, our Director of Planning Coordination. My name is Joe Griffiths. He said it a few times. I'm our Local Assistance and Training Manager. That's one of our divisions that provides most direct support to municipalities, but also counties as well around the state. We have 6 regions. Keith Lackey in the back works in our Lower Eastern Shore office in Salisbury. So we're going to kind of tag team this teaching endeavor. I'm going to start off with foundations. We're going to go into the legal and some other topics after that. I encourage you to ask questions. But for the listening or the virtual audience, if you ask a question, I'm going to have to repeat it. But for time's sake, unless it's a very urgent question, we'll ask you till the end of each module or each section to hold your questions. All right. Sometimes this thing is delayed too. Hold on. I knew what I need to do. I need to activate that. There we go. All right, I think I skipped something. All right, what makes Maryland unique, right? So we all at least work in Maryland here, right? Maryland, Eastern Seaboard, proximity to DC. We have the ocean. Here we are in Ocean City, beautiful mountains. So it's been a magnet for growth for a long time. And planning has been active in Maryland. It's been a focus in Maryland for centuries. All right, so we all know that Maryland's fairly small. See right here where it is in landmass, so very small. But when it comes to population, we're right there kind of in the middle, maybe a little bit above the middle. So we're a dense state. And with that density comes the need for focused planning, right? You don't want it to be dense everywhere. You want to attract population, you want to encourage population, but there's certain areas you want to preserve, and we're going to be talking about that as well. All right, there's a history of good planning in Maryland, as I mentioned. It goes way back, and I'd like to say it's still continuing, and you'll learn more about that throughout the rest of this class. So Maryland planners help determine the efficient use of land for homes, stores, jobs, schools, services, employment, all that. But also, as I mentioned, protect farms, forests, and natural resources. So before we get started, so it's not just me talking all the time, what are some other resources that you think planners should be concerned about preserving? So I mentioned farms, forests, and natural resources. What are some other ones? And I'll have to repeat what you say. Agriculture. Okay, thank you. Look like you were about to say something. No. Water. All right. Give me one more. Okay, existing housing, right? It's not all about making new stuff, right? There's some existing stuff that we want to preserve, could be even historic resources. All right, so somebody mentioned agriculture. Now, agricultural preservation is something that Maryland takes very seriously and has for a long time. There are what the state calls priority preservation areas, which are designations for land that contains productive agricultural or forest soils and supports profitable agricultural and forestry enterprises. There's also the MALP. It's got a funny sounding acronym, but it's the Maryland Agricultural Land Preservation Foundation, which is governed by the Department of Agriculture, established way back in 1977. It's, as I mentioned, a history of good planning in Maryland. We've known about these things for a long time. And MALP purchases agricultural preservation easements to hold land in agriculture in perpetuity. MDP, or the Maryland Department of Planning, sorry, I'll probably say that a few times. We sit on the Rural Legacy Board, another program listed here, and Rural Legacy provides funding through the Department of Natural Resources. So you see here, there's multiple different agencies in Maryland that are focused on not just land preservation, but agricultural preservation. They preserve large contiguous tracts of land to enhance natural resources, agricultural, forestry, and environmental protection in the state. You see here a map of the various programs and land that is preserved in the state. Question? Well, and I would say this is just through these programs. And I'll say right here, if you go to, I was going to talk about this next, that's just for those programs. And I'd have to go back and look at if that specific map we had on that slide is the most current one. So I don't want you to think that there's nothing preserved in those counties, but some things are preserved locally, some things are preserved at the state level. But if you're really interested, I would encourage you to go to this. This is something we created a few years ago. It's an interactive dashboard that shows, at statewide and also at the local level, which lands is preserved. But we can also get back in touch with that specific question. Land preservation is not my specialty, but I don't want you to think that there's nothing preserved in those counties. All right, but yes, I definitely encourage you to check out our land preservation dashboard. All right, so planners also protect historic resources. The Sustainable Communities Tax Credit has helped rehabilitate about 4,400 historic buildings and create 25,000 jobs since 1996. And the state's investment of about $350 million has reached into all of Maryland's 23 counties and the city of Baltimore. Welcome, new folks. All right, historic preservation is very important in Maryland and defines Maryland. So the Maryland Historical Trust, which is the state's or Maryland State Preservation Office, that actually became part of the Maryland Department of Planning in 2005. So that we work very closely with the Maryland Historical Trust. The trust focuses on identification, protection, and enhancement of heritage resources throughout the state. And they undertake surveying, they do agricultural work, archaeological work, documentation. There's Jefferson Patterson Park and Museum down in Calvert County. They also provide lots of funding for historic preservation. So we have a very, very strong staff at MHT. And, when we talk about placemaking, we talk about, what was mentioned earlier, the things you want to preserve. Maryland has long history, and it's something that is really valued here, and we want to make sure that it is continued to be preserved. And there's various programs, I'm not going to go over all of them, that MHT oversees. All right. The trust administers several programs aimed at protecting these properties. I'll go over some of them. The MHT's Review and Compliance Program administers review of state and federal undertakings to ensure that Maryland's historic and archaeological properties will not be adversely impacted by new development. The Historic Preservation Easement Program is the highest form of protection. So that's similar to, say, an agricultural easement, which will preserve agricultural land for that use in perpetuity. Historic easement will do the same for historic resource. MHT, it's not all just prevention and protection. They'll also provide direct assistance to local governments and counties, because counties and municipalities will have their own historic preservation programs, and MHT will provide that support. So I hope you, if you're not familiar with your local MHT or an MHT officer or staff member to help your community, we can definitely connect you with them. And then MHT updates its state historic preservation plan every 5 years. It's required to do that. They're currently undertaking it right now. So the last one was Preserve Maryland 2. Kristen, do you know if the new one has a name yet? The new historic preservation plan? Yeah, I think they're still developing the name, but they put out a survey recently. They're doing interviews, so they're deep in the outreach process right now. Okay, so let's talk about the future of good planning. We've looked at historic preservation, agricultural preservation. So what are some things planners can do to ensure a future of good planning, either at the local level or state level? Yes, sir. Enforce the comprehensive plan. All right, you want to give us a little background on what a comprehensive plan is? We're going to be talking about it later, but just for those who might not be familiar. Okay. Okay. All right. Thank you for the background. Yeah, it's a comprehensive plan, hence the name, is something that kind of oversees development and the plan, preservation, all the aspects of planning within a community. We'll talk about it more. Somebody give me one more example of how planners can ensure, not just planners, it could be somebody who's just working at the local level, an official at the local level. You know, I'd like to think that a lot of people are planners, even if they don't know it. Yes. All right. So we talked about comprehensive plan, zoning, those obviously work very closely together. And one more, yes, sir. Yes. Community engagement, outreach, making sure you have your stakeholders are involved. And citizens could be anybody from somebody who lives in your community to business owners, organizations. Yes, that's another key aspect.
So Joe, just for your, make sure you please either repeat what people are saying in the audience, because some people online said they can't hear. And one person mentioned good planning returns on infrastructure investment.
Infrastructure investment. Okay, yes, I'll rely on you to help with monitoring the chat online, because we don't have it open right now. But yes, infrastructure investment, capital investment, absolutely a part of that as well. All right, so this is a question from a slide that my colleague Chuck Boyd has put up here, because he has a long history with this community. So we're looking at this beautiful shot here. Is it London? Is it Copenhagen? Is it Venice? There we go. I think that one's kind of giveaway, but Chuck he lives in Frederick and had a lot to do with the development of this, and is close to his heart. So I know he's probably disappointed that he's not the one able to show this slide right now. Boom, Frederick, Maryland, you got it right. All right, let's look a little bit of the history of planning, because it goes way back as well. In 1916, New York City adopted the first comprehensive zoning regulations to apply citywide, which became the model for zoning in the rest of the country. It regulated height, bulk, and use. We're going to get a lot more into zoning with the next presenter. And there was a standard zoning enabling act of 1922 under Herbert Hoover's Department of Commerce. He was the secretary back then. Kind of helped give some examples and helped other communities enable zoning within their communities. Daniel Burnham, if you'd study the history of planning, Daniel Burnham will always come up. We made a joke. There's a certification you get called AICP, and if you don't know the answer to a question, you just put down Daniel Burnham, and there's a good chance you're going to be right, especially in the history section. He played a leading role in the creation of master plans in Chicago, Washington, D.C., and he famously said, "Make no small plans." So you think about the early 8 days of planning, that was like the mantra, go big, right? And that persevered for a long time. And here's Edmund Bacon. He advanced redevelopment in Philadelphia in his long stint as planning director there. All right, the plans for big industrial cities at the turn of the 20th century, such like Daniel Burnham would have been involved in, they recommended extensive redevelopment, huge infrastructure projects. You know, the populations of cities were booming at that time, right? And they need to plan for them. see. I'm sorry, I shouldn't have gone, well, I'll leave it here. In the mid 20th century, however, some of the post-industrialism started to set in, right? And there was this need to look at redevelopment started to take a stronger hold. And that led to something called urban renewal that we're going to learn I'm going to talk a little bit more about here, which didn't always have the same positive impact. And as we have here, every profession has its darker corners. All right, I'm not going to read these to you, but you can come back and look at them and see some classic early statements about planning. All right, so let's see, urban renewal. But as I mentioned, urban renewal has some negative sides. So the history of planning isn't one of uncheckered progress. Following World War II, planners and civic leaders in cities throughout the country enacted this, and it aimed to often clear and redevelop areas that they would classify as slums in the name of civic and economic progress. And this is often with the support of federal funding at that time. But these slums were often working class or minority communities, and they had vibrant communities, vibrant economies, vibrant culture, but often these big planners focused on urban renewal would say they were getting in the way of progress, right? And they often didn't have this community engagement that we were talking about earlier. They didn't engage people to live there. So this led to things like freeways, large economic development projects just going through communities, displacing people. And over the years, we learned a lot of lessons from urban renewal, and it's something that we definitely strive to avoid these days. This Jane Jacobs, has anybody here heard of Jane Jacobs before? She, very famous, was pushed back against urban renewal in New York City. Robert Moses, known as the Power Brokers, very famous book about him. He was more of an advocate of the urban renewal. She pushed back and she wrote this classic book. If you're in planning school, you basically have to read The Death and Life of Great American Cities. And she has, she started talking about how the importance of density. Her famous line is "eyes on the street," and she successfully was able to push back on some of Robert Moses's plans. Let me see. Make sure I don't want to give her any short shrift here. She argued planning ought to be about people, not buildings, right? If you look at the make no small plans aspect, urban renewal is kind of focused on the buildings, and she kind of gave it a more grassroots, human-based perspective. And in that way, this principle remains a core principle of planning to this day. So she's very, very influential. And she was not a professional planner, and that's why I kind of said earlier, everybody can be a planner. We want to consider that everybody has a role in it. Okay, so why do we plan? First and foremost, so that we can guide sustainable and efficient use of our land. It also helps us figure out how much public infrastructure, water, sewer, roads, schools, all the things we are so important at our public meetings, how much we need to support that population growth. Planning helps us protect sensitive resources, as we mentioned earlier, wetlands, forests, even agriculture. And it's highly interdisciplinary and has many different areas of focus, similar to as the legal profession does. When I tell people I'm a planner, they always ask me to fix their roads or a pothole in the street. And that might be something that I do, but it's very hard to describe, even to my family, anybody, what a planner really does. But we do so many different things. One planner doesn't do the same thing that another planner does. It's very interdisciplinary. So what is the role of planning? It's to understand the physical landscape and a diverse and dynamic population, gauge the appropriateness of developments and the capacity to fit them into the whole and fit it into a whole that is greater than the sum of its parts, and combine and synthesize different ideas to provide a vision that appeals to residents. Okay. So similar to urban renewal, there's more dark corners of the planning profession, right? So the role of planning has not always been positive. Going back even further than urban renewal, and with the support of New Deal policies, planning and planners also contributed to racial segregation and social injustice. This is Baltimore's 1937 residential security map, otherwise known as the Red Line map in Baltimore. Those areas shown in red are were predominantly African-American communities, and they were labeled hazardous, and therefore mortgage lenders and appraisers denied services, loans, and capital investment within the red lines. All right? So the New Deal's Federal Housing Administration denied minority households access to the federally backed guaranteed mortgage loans created through the National Housing Act of 1934. So the New Deal, right, in that respect, when it came to housing policy, really was supporting white families, white households, and holding back the same benefits to minority households. And you'll see throughout the country, I mean, Baltimore isn't the only community, right? This has had very negative impacts on communities across the country. And you'll see these areas that are redlined are still some of the areas in Baltimore that are struggling the most. So you know, it's this long history that planners have to realize and accept has happened, but also push back against. All right, so their planning for equity is becoming much more of a, I mean, it's been around for a while, but that's the term that's being used now more often. It is gaining ground, it's gaining steam, and I know it's something we talk about at the Maryland Department of Planning a lot. It's key to understand and address the history. This has to do, I talked about urban renewal, talked about redlining. You need to realize that it happened, be honest about it, and then, you know, how do we address it? You have to overcome the legacy of distrust. A lot of people in the country and our communities don't trust planners because they put a freeway through their community, or they didn't listen to their concerns about environmental pollution of that industrial use. So that there's a long legacy of distrust that's unfortunately really well earned. There are ways though, planning academies and authentic participation. Baltimore City has a planning academy, Howard has a planning academy, Prince George's has a planning academy, where they train their residents in the key concepts of planning in their community, and they get them much more heavily involved than just say coming to a public hearing. They're actually providing them direct training, kind of like the training we're providing you all right today, but specific to their community. Focusing on equitable organizations, empowering equitable organizations in your community, using equity lenses. This often has to do with capital investment or land use decisions. Applying as part of your criteria when you're making these decisions, what is the impact on equity, especially compared to historical legacies of inequity, right? Where focusing capital investment in communities that may have been denied that capital investment over the years, or when you're making decisions on environmentally polluting uses, right? You know, keeping that in mind, making sure that equity is a consideration in your land use decisions. And as I mentioned, yeah, capital investment. Here's public participation is a big aspect of it. Sherry Arnstein is a person that we also learned about in planning school. She did the ladder of participation. And because there's all sorts of different levels of citizen participation, right? You could be telling somebody what's going on. Is that really participation, right? You got the lowest level is manipulation and therapy, but then eventually you get up to the higher levels of actual citizen control, or where citizens, you know, it's a spectrum, right? There's certain things you need at different levels, but how can you really empower your residents, your stakeholders, to take an active role in planning in your community? And these are some of the keys ways to plan for equity and overcome some of those negative legacies. All right.
So there are no questions online, but I'm going to encourage us to keep on going because we're running a little behind already.
I'm a little behind. Okay. All right. I think I can get through this pretty quickly. So we'll get to the legal aspect of it even more here in a second, but Maryland delegates authority to municipalities, counties, both charter and non-charter, through the land use article. And then there's other planning related state legislation. When we get to comprehensive plan zoning, that we'll also go over as well. But it's key to know that Maryland delegates this planning and zoning to municipalities. So this is MML. So not all municipalities have planning and zoning authority, but most do. All right, so the land use article used to be called 66B. That's the main one to note right here from Article 66B. Division 1 is going to be most, and then Division 2 is specific to Montgomery and Prince George's counties through the Maryland National Capital and Park and Planning Commission. Here's a map of charter or code counties and non-charter counties. It's not as since we're at MML, this is not as much of impact to you, but there are some different planning requirements, different delegated authority for non-charter counties versus charter counties. I'm not going to go over all of these, but this is a overarching timeline of some of the bigger planning aspects in the country. And when we get down, Adam is going to talk a lot about Euclid when he gets to the legal aspect, legal portion. So here's some Maryland planning milestones. Way back in 1933, we created a state planning commission. The Maryland State Department of Planning started in 1959. We've been the Office of Planning sometimes, but we're back to being a full-fledged executive agency now. State Land Use Act, and then some of the bigger ones are, some of you are probably familiar with priority funding areas. And we're going to talk about those more later on. 1997 is a big line in planning for us. It's like what happened pre-1997 and post-1997, because the priority funding areas have a big impact on how smart growth is a common term used in Maryland. And again, you'll learn more about that. And then the Sustainable Communities Act, that's trying to really focused on concentrating our capital investment, revitalization investment in existing communities. Priority funding areas, all right, this is where we try to focus state funding, growth-related funding, water, sewer, roads, but also preserving farms and natural resources. And a more colloquial term, and I think like this is a way to reduce sprawl. Really kind of, if we can focus state investment in certain areas, preserve other areas, right? We can accommodate that density that we talked about earlier, the growth in Maryland, while also preserving the things we want to save. All right, the key aspects of them to qualify for priority funding area, even though they're designated locally, it needs to have existing or planned water and sewer service. If it's zoned for residential use, it needs to have a density of at least 3.5 dwelling units per acre. And it needs to be, the growth plan needs to be consistent with projections. So you can't just make everything a PFA. It's more targeted than that. And it needs to be in the locally designated growth area. So essentially PFAs are through zoning, through infrastructure planning like water and sewer, and through a comprehensive plan, a local community has said, we want to grow here. And if you meet these criteria, the state will concur with that. And then that makes those areas eligible for certain growth-related funding at the state level. All right, so this is up to 2018, so a few years behind, but still fairly updated. If you get here, all right, yeah. All right, so the number of parcels, right, is on the left. The number of parcels in PFAs, much larger than this is the land that's inside PFA. But if you think about that, that makes sense because PFAs are going to be, you have that 3.5 dwelling units per acre we talked about. So you're gonna have smaller parcels. So you're gonna have much more dense development. So you're gonna have a lot more parcels in PFAs, but the actual land, when we kind of agricultural land, other land we want to preserve, we want that outside of PFA. So those are bigger tracts. So it makes sense that those would be, the more acres would be outside of PFAs. All right, so these are just some of the trends that Maryland has to be considering as it plans over the next 20, 30 years. Expecting 600,000 new jobs, and movement of jobs outside of urban communities contributes to decline in established towns, cities, and towns. So if we have this growth, right, we know it's not all going to go to established cities and towns, but we want to, as much as possible, encourage growth in our existing communities because that the infrastructure exists there, it maintains the vibrancies of those communities, but also preserves things like agriculture and other sensitive land that we want to conserve. All right, so here's some other indicators of growth over the years. So from 1998 to 2008, 157,000 acres for residential development. But then from 2009 to 2018, 50,000 acres for residential development. So you can see the impact of smart growth, but also market dynamics, right? We're not foolish enough to think that like PFAs and smart growth are going to do everything. Market dynamics play a big aspect of this, but you'll see some progress there, right? Less what we call green fields, open areas, be it agriculture or others, fewer of those acres being developed for residential. Okay, I'm happy to take any questions about that before we get into the legal portion. The legal portion is always the most exciting for folks, so I don't want to hold back.
You want to turn your webcam on for a second?
Sure.
So Joe, we have one question here is the 3.5 dwelling units per acre density calculated based
Hey,
upon
Chuck, I'm
gross
sorry.
land?
Hey, Chuck, I'm sorry. There was a question here. I was just going to repeat it,
Okay, sorry.
and then we'll get to that question. Continue. I'm sorry, sir. Yep. The location. So the question is, it's based on this slide. Do we have data that indicates where these acres that were developed for residential development are? And we do. I don't have it on me, but we could get that for you. We've been tracking that, but also local communities do as well. Chuck, I hope you heard. Oh, actually, yeah, you're right. Should share the webcam. That's right. When we're answering questions, I'm supposed to be. There we go. Go ahead with the question you had, Chuck.
Yes, thank you for putting in the webcam. Folks were wanting to see you guys in the audience. So the question is the 3.5 dwelling unit per acre density calculated based upon gross land area in the PFA or the net of sensitive features like forest, wetlands, and or parks? And I can answer that question for you. You can add to it. The answer is it's net acreage. So often you actually calculate the density once you've taken out your roads, your dedicated park areas, any open space to homeowners associations. And so the density is calculated solely on the actual residential units that are being created in a subdivision. That's the only question we have here.
Okay. Thank you, Chuck. Any other questions in the room related to the foundations of planning or anything else? Yes, sir. Yeah, I mean, the pandemic is fresh and new. I'd say it's more anecdotal than anything else. I don't know if we have, I mean, I know we've monitored it, and we've talked with local communities about, the ability of people to telework and that aspect changing where people decide to live.
Do you want to repeat that, Joe?
Oh, I'm sorry. Yeah, I should have said the question, my part. The question was, have we seen any impact of the pandemic on land use patterns and residential growth in the state? And I said, and Chuck, if you have something else to say, feel free to let me or to chime in. But I'd say at this point, we are monitoring it, but it's more anecdotal than anything else. Understanding that people have more freedom to choose to where to live, and maybe they're looking for more room, more space, more land, and they can telework, so they're moving to more rural areas. I don't know if we have. I would say we don't have a comprehensive analysis or handle on how that's happening yet. Some communities may more themselves. Chuck, do you have any?
Yeah, you're on track. So particularly in the Maryland Department of Transportation is studying the issue of teleworking, and it is evaluating its impact on how imperative it is to move forward with certain improvements. We know our roads are congested in certain areas, but they are seeing a slight decrease in the peak hour trips, and people are adjusting more so. It's a little early in terms of us to being able to see a lot of change in land use patterns. We're going to continue to monitor that. Since the pandemic was a couple year period of time, there has been a rebound in certain areas. Transit has rebounded in certain areas, in other areas it has not. So it is likely that there will be some long-term impacts related to COVID encouraging teleworking more so. So this hybrid training is a perfect example of us responding to the market forces and the technology related to COVID. So more to be studied.
Yeah, I'd say it's something that a lot of planners are realizing we need to be focused on, because there's lots of benefits of teleworking, right? It can lead to less congested road, fewer greenhouse gas emissions, but also, the demand for office space you see in all the major cities is like plummeted. And, having that downtown or even just Main Street in a smaller town, working day population there supports a lot of small businesses. And when people are teleworking, so it's where's the balance? And I still think that a lot of communities and a lot of jobs, a lot of employers are figuring out where that balance needs to be. So yes, question. Oh, I see. All right, he's getting serious data question here about our numbers. No, it's a good point. So the question is, this slide is showing the acres that were developed for residential development in comparison over two 10-year periods, but the question would be how many actual units were created. So is this decline we're seeing from 157,000 to 50,000 acres, what's the cause of that? Is it only smaller, more dense lots, or is it because there was actual overall less development? I don't have that number on me. We could probably get some of that. I mean, we know from leading up to 2008 was the housing bubble and the housing boom. So I imagine that in those 10 years there's more growth in total units from 1998 to 2008, but I don't know exactly where that line is. But that's a good question. That's where it gets back to like market dynamics. Market forces have a big aspect here, and smart growth, PFAs can only help guide development, whereas the market is going to be the primary driver.
Yeah, we're gonna need to move on, Joe, soon.
All right, last question, then we need to move on. Yeah, sorry. But yeah, well, I'd say that housing in all of its forms, affordability, fair housing, production of housing, is something that almost every state agency has at the top of their priority list right now. I know our Secretary Flores, involved in an interagency work group on housing, and just the need for the greater supply of housing in Maryland is well understood. The Department of Housing and Community Development did a housing needs assessment and 10-year strategic plan a few years ago, and some MPOs, some regional planning agencies from Baltimore down in the Washington metro area have calculated for the growth that we expect, and especially at affordability level, like a whole lot of, I mean, our supply of housing is not sufficient. And it's a very tough nut to crack. A lot of this is governed locally as well, but the state is very focused on providing incentives and funding to help increase that supply, and technical assistance and resources and best practices to locals on how they can help increase that supply. But yes, it is at the forefront of many, many conversations. All right. I know
so
we need
Joe,
to get to
you have questions to go through.
Oh, okay.
No, you have questions to go through in your test.
We're done in here.
No, you move forward your PowerPoint. You have questions.
Oh, sorry, forgot. All right, true or false? Maryland is the 5th most densely populated state. I didn't say the number, so this is a hard question. It's true. Yeah, sorry. So we're small, but we're pretty densely populated. All right. By 2040, Maryland is expected to grow by how many or all these things? It's all the above. Why do we plan? Oh, yeah. The answer is usually if you see all the above up there, it's going to be the answer. All right. Where do the Maryland jurisdictions get their planning authority? Yes, the land use article. And priority funding areas. A, correct. They are located inside growth areas, are drawn by local communities, local governments, and do not include only municipalities.
All right, everyone. My name is Adam Snyder. I'm an Assistant Attorney General and Principal Counsel to the Department of Planning. I'm going to be talking about the law. I never like having a lecture of mine billed as being exciting. It's rare that a lawyer's talk is exciting, and so I'm not going to meet that standard, but hopefully we'll cover some ground that'll help fill you in about the constitutional underpinnings of planning and zoning authority, limitations on that authority, and then give you an overview of planning and zoning law in Maryland. And then we'll finish up with a subunit on government ethics. I will be breaking for questions through as I work my way through this outline, so you'll have opportunities to ask questions immediately after I cover a topic. So now, the constitutional authority. It all begins with the 10th Amendment of the US Constitution, which is called the Reserved Powers Clause. And it provides that the powers that are not specifically delegated to the federal government are reserved to the states or to the people. And among the reserved powers is the police power, which is, regulating for public health, safety, and welfare. There's no federal police force, so to speak. You have stuff like the FBI, but you have local police, and that flows from this concept that the police power is principally exercised by the states. Now, you'll never really have to be familiar with the 10th Amendment. It's a fairly esoteric amendment, but it comes up mostly in debates about states' rights, as it recognizes our nation is really a collection of sovereign states that have agreed to unite for a common purpose. But the Reserved Powers Clause is one of the ways in which our Constitution recognizes this kind of residue of sovereign powers that lies with the state. Now, why is that relevant to us here? It's because the police powers is the basis for local zoning power. And that was first recognized in the Euclid versus Ambler Realty Company case from 1926. Now, some of you may have heard the term Euclidean zoning. That comes from the name of this case. What happened in the case was the town of Euclid passed a zoning ordinance that divided the village into several districts, things like industrial, residential, commercial, zoning districts. And the Ambler Realty Company owned 68 acres of land in the village, spanning multiple districts. And as a result of the zoning, it was going to be restricted in the types of buildings it could construct on its land. Ambler sued, claiming that the ordinance violated its constitutionally protected liberty and property rights. It owned this land, it owned this property, and it felt that it should be allowed to develop its land the way it wanted to. A lower federal court agreed, but the Supreme Court reversed. It upheld the zoning ordinance, concluding that it was neither arbitrary nor unreasonable, and thus did not exceed the local government's police power. And so the court tied it to this font of local police power that, as the standard applied there, it wasn't arbitrary or unreasonable, is a fairly broad standard, very deferential to local powers. But it's important to note what the court didn't say, and that is that it wasn't saying that all exercises of zoning power would be constitutionally appropriate. It specifically said site-specific applications of zoning might implicate other constitutional limits, and the one that it principally implicates is the Fifth Amendment. The Fifth Amendment provides, nor shall private property be taken for public use without just compensation. Now, there's only 12 words in the takings clause, and the 7 ones that appear on your screen in blue have generated literally thousands of court decisions defining the line between private property rights and regulation in the public interest. Now, we're not going to be talking here today about the definition of private property or what it means to be a public use or what constitutes just compensation, even though all three of those terms are heavily litigated. But instead, we're going to focus on what it means to take property and what constitutes a taking, because that is going to bear most directly on the work that you do. So there are three forms of takings. There's eminent domain, regulatory takings, and certain types of exactions. And we're going to cover all three of those in turn, starting with eminent domain. Now, this one you're probably intuitively familiar with. When the government comes knocking and wants to build a road or a park through your backyard, the government can do that, but they just have to pay you compensation for the land that they're taking. You probably won't have an awful lot to do with straight exercises of eminent domain. That's something that really is implicated by departments of public works that are doing major public works projects. That really they deal with that all the time. An agency like the State Highway Administration is frequently condemning land and invoking this aspect of takings law. The real action, though, is when the government doesn't directly take your property, but instead regulates it in a way that lessens its development potential. That's the concept of a regulatory taking. Now, that seems pretty straightforward. You're taking a property through the impact of law of regulation. But the problem is that there really is no express constitutional underpinning of that at all. Again, the language of the Constitution just says taking. And in the beginning of our nation, there really weren't any regulatory taking. So it's a concept that was foreign to our founding fathers. And that's because there wasn't an awful lot of regulation going on. When you did have kind of property-related regulation or property or takings challenges to government action, it was things that were like very core exercises of the police power. For example, if there would be a fire raging through a city, the city would come and have to create a firewall by knocking down houses that stood in the way of the fire to create a break so that they'd be able to contain the fire and it wouldn't keep spreading throughout the city. And some property owners understandably sued and said, hey, you knocked down my property. You've got to pay me for it. And the government would win those cases because it was an exercise of the police power. It wasn't regulating your property. It was destroying it for the common good, because otherwise it was going to burn down the rest of the city. So in the beginning of takings jurisprudence, the government would typically win because it was doing very little regulating. What it did was very closely related to public health and safety, kind of writ large, and it was protected by this concept that if it's a legitimate exercise of the police power, it's not a taking. Well, that concept started to get strained when you moved into the 20th century, because you see the growth of the administrative state. And when that happens, you get government lawyers like me who would be arguing that everything the government was doing was an exercise of police power. So the Pennsylvania Coal versus Mahan had to do with regulating the removal of coal under the ground in order to leave a sufficient support of the surface so that you wouldn't have sinkholes and stuff like that. And the lawyers for the government argued that, well, this can't be a taking because it's an exercise of the police power. And the Supreme Court on that topic gave the quote here that I've highlighted for you, that if uses of private property are subject to unbridled qualification under the police power, quote, the natural tendency of human nature would be to extend the qualification more and more until at last private property disappeared. The court saw that this was going to keep happening. You're going to keep having government lawyers saying, it can't be a taking here because this is an exercise of the police power. And that concept of police power would just keep getting broader and broader, and the takings clause would just disappear. So the court is signaling that the police power is no longer a get out of jail free card for the government. But what constitutes a taking? The best the court said in the Pennsylvania coal case was, while private property may be regulated to a certain extent, if regulation goes too far, it will be recognized as a taking. Well, of course, begs the obvious question, what is too far? And the court has continued to struggle with that question for the next 100 years. The first effort to solve that question came in the Penn Central case, which involved a proposal to build a new office building on top of a historic building. And it was denied, and the Penn Central company brought the case all the way up to the Supreme Court. And the Supreme Court said, well, you know, it's difficult to determine how far is too far, but we're going to identify these three different considerations that courts should look at in evaluating whether the government has taken private property. The economic effect of the government action. What does it do to the value of the property? Reasonable investment back expectations. Did you buy the property at full fair market value, or did you buy it at a discount because you knew that the property was subject to regulations that would limit its developability? And the character of the government action. Does this look like a direct taking, like the government wants to keep you from developing your property so it'll be like a park for everyone else? Or is the government doing something else that's closer to an exercise of traditional police powers? Still, though, this is a very flexible test. It's got no bright lines at all. And statistically, the government was winning the vast majority of these cases. That began to change, though, in the 1980s and the 1990s as the Supreme Court started to try to draw some bright lines that could provide some predictability to takings law. And the first categorical or per se takings, those are terms you'll hear, was the Loretto versus teleprompter case in 1982. This was a case where New York enacted an ordinance that required all apartment buildings to install cable boxes, or like cable routing boxes, on the side of their structures, so that the city could provide cable service to everyone within the city, or everyone who would pay for it, of course, but provide cable availability across the city through these this infrastructure. And you see the picture in the lower right-hand corner. It's something like that. Not a big imposition. It's about a 3-foot by 3-foot box that had to be installed on the apartment owner's property. And one of the property owners, one of the apartment owners, sued, saying, hey, you're putting something on my property that is I don't own. You're forcing me to do it. And that's a taking. And the Supreme Court agreed. It said that this is a physical occupation of property. And when the government does that, no matter how small, no matter, even if it has no effect on the value of the property, that is a taking. So it's commonly called a physical taking. If you hear other presentations about takings, you'll hear that term a lot. So physical takings is one of the categorical takings. The second one is based on the lawsuit of Lucas versus South Carolina Coastal Commission from 1992. This involved, you see the picture on the side, the empty lots that were between already developed lots along the South Carolina beach. And Mr. Lucas owned one or both of the lots. I think it was both of these lots. And he was told that he couldn't develop them because South Carolina had enacted I think it was called the Beachfront Management Act, which prohibited the construction of residences and other occupiable improvements seaward of a line drawn parallel to, literally a line in the sand. And there were many houses that were already beyond that line in the line in the sand. But South Carolina says we can't do any more because we need to protect the dunes that are here, and so we can't be raising those dunes to put up houses. So Mr. Lucas had two, previously developable beachfront lots that all of a sudden he couldn't do anything with. And when the case got to the Supreme Court, the parties were arguing about whether it was, well, it's not really true that he can't do anything with it. He can camp on it. He could, put like something more than a beach umbrella, as long as it's not an occupiable structure. He could do a lot of things on it. And the Supreme Court rejected that and said that when the government regulation denies a landowner of all economically viable use, it constitutes a total taking, or a per se takings. You'll hear this referred to as a Lucas style per se takings in Mr. Lucas's honor. Now, all takings plaintiffs in land use cases try to get into this box, into the Lucas box, because again, the Penn Central test has proven very difficult for private property owners to prevail under. But if you get into the Lucas box, well, you automatically win. The problem is that it's kind of difficult to get into the Lucas style takings, because a diminution of value is not enough. I mean, it's not enough that the government regulation deprives you of 75, 80, 90% of value. It has to be a total take or total loss of value, or something very close to that, something north of 95%. And that's, hard to, that's kind of the rare case that'll have that type of effect. Mr. Lucas fell into it, but ordinary wetlands regulations, which is a big source of takings cases, typically don't involve that great an impact on value. So what plaintiffs often try to do is recast their claims to get into the Lucas box. So, let's say you own 100 acres of land, and 50 acres of it is wetlands, and you have been denied a permit to fill that wetlands to develop it. And when you look at it on it denies you 50% of the value of your property, roughly, and that's not going to be a taking. So people would try to define the property differently and say, well, I'm only sought to fill the wetlands. So you don't look at the rest of the property, you only look at the 50 acres of wetlands that was affected by the regulation. And the court rejected that approach, said that you have to look at the property as a whole and not break it into the affected segment. So there aren't any per se rules for partial takings. You really have to look at the property as a whole. which again makes it difficult to get into the Lucas box. So that here we are, 30 years after Lucas, and still most of the cases are decided under the Penn Central case, under which again the government typically fares pretty well. Why don't we take a quick break for questions here, if there are any, because I'm going to move into exactions, which is a form of takings, but it's a little bit different. So Chuck or Joe, do you got any questions?
Yeah, there are no questions from the virtual. Oh, so we just got one here. At what point does a newly enacted local ordinance apply to a developer's land use application? Must the developer have submitted a complete application before enactment of the ordinance to be grandfathered? So you're going to be covering vesting a little bit later, but I don't know if you want to touch this at all.
Boy, that can really depend on the law involved in the ordinance. They can be written both ways so that they're applicable to pending applications or not. So it's hard to say. There's no constitutional grandfathering principle that applies across the board. It really comes down to how you structure your ordinance. And we will be talking about vesting, which is related to this, and perhaps it'll shed some light on your question.
So Joe, are there any questions in the audience there?
Not yet. Any questions?
I'm going to be here for a while, so if one occurs to you, you can ask it later.
So go ahead, Adam, and proceed,
All right.
and we'll get the questions queued up
Very good.
for the next time.
Very good. Okay, let's move on to exactions. An exaction is not the government coming and saying, we want your property. And it's not the government, issuing a regulation that bans development in an area that could give rise to a regulatory take. Instead, it's a condition placed on some type of government approval, like a permit or a special exception, that is applicable to a specific property. And under certain conditions, it can amount to a taking. There's two requirements here that for an exaction to satisfy constitutional scrutiny, and there has to be a rational nexus between the condition and the problem that the government is trying to get at, and there has to be a rough proportionality between the impact of the condition and the impact of the permitted activity. Now, I'm going to talk about the two cases that these two principles were derived from, because I think they're helpful in understanding what these two criteria, what they mean. So the Nolan versus California Coastal Commission case, you see the arrows there. The Nolans owned a small house. They wanted to take it down and build a much bigger house. And the government was concerned that by building that bigger house, it was going to reduce the public's view of the beach and of the ocean. That's part of, you live in California, this is kind of what people like. They'd like to be able to walk down the street and look out and see the ocean. And they said, well, you're reducing that visibility. So we want you to give to the government an easement across your private beach. You see that to the left here. Oops, sorry. I was hoping to use there we go. The private beach that the Nolans own, the government said, okay, we'll let you put in the bigger house, but you've got to give the public an easement across your beach. The Nolans challenged that, and it went all the way up to the Supreme Court, and the court found that this constituted a taking. Because when you think of it, there really is no rational nexus between the government's concern about reducing the public's view of the ocean and giving the public a easement across the beach. Though they really don't have anything to do with what the imposition has nothing to do with the construction of a larger house, because the larger house is not affecting anyone's visibility along the beach. Maybe the government there could have said, we want you to, allow us to build a walkway that will go to a viewing area alongside of your house so that people could see the beach. That would at least have a nexus between the viewshed impact the government was articulating and the condition that it was requiring. But in this case, there wasn't that kind of nexus, so the Supreme Court found a taking. The next big case, and luckily it has a name that rhymes with Nolan, so that you get the Nolan-Dolan principle of exactions. This is the case from which the rough proportionality principle came from. And what it involved was the owner of a business applied for a permit to expand their store and pave a parking lot. And the permit was conditioned upon the installation of on-site mitigation of stormwater impacts, and the landowner had to give up other property that it owned to create a off-site public greenway that would also be able to hold floodwaters in certain conditions. The court held that the dedication of private land for public use constituted a taking because it was not roughly proportionate to the city's legitimate stormwater management objectives, when the permit already required on-site mitigation. So there must be this rough proportionality in nature and degree between the impacts of a proposed development and the impact-related exaction. And the idea here being that, well, if you're already requiring on-site stormwater management, you have to show that you need to do this off-site public greenway project in order to mitigate for this store's impact on stormwater. And the government wasn't able to do that. The off-site greenway was much larger than was necessary, according to the Supreme Court, and it was in a different area, so there wasn't this, it didn't have this sufficient connection to the impact that was seeking the activity that was seeking a governmental permit. So a couple things to remember, though, about exactions is that they are always applicable only to property-specific impositions. They're not challenges to regulations or anything like that. And it's about a permit. It's the condition of a permit or a fee or something placed on an individual property owner's request to develop their land in some way. So it doesn't apply to, broadly imposed tax and impact fee ordinances, which are fairly common because those are legislative in nature. They apply across the board. They're not developed to apply to a specific property. All right, well, that's the Fifth Amendment based limitations on local land use and zoning. Let's talk a little bit about the Equal Protection Clause. Nor shall any state deny to any person within its jurisdiction the equal protection of the laws. Now, this is a very, unlike the 10th Amendment, the 14th Amendment is kind of ripped from the headlines. It's the font of a lot of familiar legal principles to us. It's the constitutional principle that led to the desegregation of public schools and has wide-ranging effect on our society. Now, in this context, where we're talking about planning and zoning, the relevant consideration here is that it applies to the Equal Protection Clause applies when the government is classifying, putting two things that are similar into different classifications and treating them differently. Now, generally permitted, you generally can do that classification. Again, putting things into two different buckets, as long as the basis for doing that is reasonable. You can have a rational basis for distinguishing between ice rinks and ice cream parlors or something like that. The only time, and that's a very, very, very deferential standard, the rational basis test, and the government almost always wins. These classifications become problematic for the government, and they're subject to strict scrutiny when the government is classifying based on either a suspect class, things like race, what have you, or fundamental rights. So the government is classifying citizens based on how they vote or things they've said publicly. Well, if you're going to speak out against the government, you're not eligible for this type of permit, but other people are eligible for that type of permit. Under those circumstances, the classification becomes subject to strict scrutiny, and the government almost always fails. Now, zoning, of course, is inherently discriminatory because that's what it's all about, is distinguishing between different plots of land and saying this land is going to be zoned industrial, this land is going to be zoned residential, and you can't build the same things in them. So you can't build the factory in the residential area. And those types of classifications, though, are constitutionally upheld because they have a rational basis. It is rational to treat residences differently from factories, and it's rational to not want to have a factory built right smack in the middle of a residential neighborhood. So that type of classification is routinely upheld, and it's why zoning hasn't been struck down in the years since Euclid. It always passes that rational basis test because zoning is not being done on the basis of race or anything like that. It's being based on the use to which the property is being put. All right, now let's break momentarily here for questions, because this concludes the kind of federal constitutional portion of my remarks. I'm about to go in and to talk more about planning and zoning in Maryland. So if anyone has any questions about federal takings law and equal protection law, speak now or forever hold your peace.
Adam, just to follow up on that first one, as I read it again, I'm going to read it one more time, and then there's a couple more here. At what point does a newly enacted local law apply to a developer's land use application? Must the developer have submitted a completed application before the enactment of the ordinance be grandfathered? And I'll just give you a planner's perspective on this when I'm working, obviously not an attorney, but working with our municipal attorneys and planning commissions. Usually in that process of providing a recommendation to the legislative body, you talk about these issues about, well, when should this ordinance become effective? And do we need to give fair opportunities for those that have projects halfway through the process? And so they usually, or they should have a discussion about when does it become effective and do you give people a chance to do it? So often it is written into an ordinance of when it is effective and giving the locals a chance to react to it one way or another. So usually it should be something that is part of the debate at the local level. So again, that's my perspective from a planner's of having to deal with these things, and often having that discussion with my planning commission of what our recommendation to the legislative body would be.
Thank you. I have one question in here. I'm going to try to have you read from the mic.
Actually, my question goes back to what just Chuck talked about. There are some developments, when you change a zoning in the regard of that property that they were taking the public view from the ocean, okay?
Mhm.
I understand that the property owner at that time, they were developing it, and it is hard at that time to change the zoning. But afterwards, if they change the zoning that you cannot make it larger, do we have to pay damages to all the other houses that they are there, that they were thinking that they were not planning to do it now, but they were thinking at some time in future, they may, plan to replace a smaller house with a bigger house. So how that works, I understand, is a very good point, but how do we take care of the existing lands that some of the zoning would reduce the opportunity for future development?
Yeah, I mean, you can get into trouble there. I mean, that's kind of what happened with Mr. Lucas's case, where, he owned these 2 beachfront lots. He wasn't developing them. And then South Carolina enacted the Beachfront, Protect Management Act. And he didn't have a pending application at the time. It was enacted, and then few years later, he put in the permit, and it was denied, and he challenged it, and he won. What it's going to come down to, again, is going to be what is the impact of the restriction. So in the Nolan circumstance, where you have that smaller house being replaced by a larger house, that's not going to be a taking evaluated when you evaluate it outside of the exaction context, because you've already got a house on the property. And sure, taking down that house and putting a big one in its place is going to increase the value of the property, but it's not like you're being denied all economically viable use of your property when you have a house, a beachfront house. Maybe the property value gets reduced by 50% as a result, or maybe even 70% as a result of the government restriction, but it would not, that wouldn't be enough to constitute a taking. There were cases that fought this issue about, well, if someone buys property after a regulation is in place, they can't bring a takings claim to challenge the impact of that regulation. And the Supreme Court rejected that as a bright line rule. But if you buy a property after the regulation is in place and you bought it for a deep discount because you knew that the regulation was in place, it's going to be much more difficult for you to establish a taking, because again, unless you can show a total take, you're back in the Penn Central box and you're looking at your reasonable investment backed expectations. And if you knew going into it that you were going to have a limited developability and you paid accordingly, it's going to be harder for you to win that case. I talked a lot there, but I'm not sure I answered your question.
We have one more question in the room, and then we also had a request for a short bathroom break. So after this question, we'll do that.
Okay.
So, Adam, could you discuss the relevance of the due process clause of the Constitution in takings litigation?
I'm sorry, can you say that again?
Could you discuss the relevance of the due process clause of the Constitution in takings litigation?
I'm going to say no. It's complicated because there's overlap between the due process clause and the takings clause. The Supreme Court has tried over the last 30 years to move its jurisprudence out of the due process field and into the takings field. So it's becoming less important for takings, for kind of land use regulation. Generally, though, I mean, you can run into due process problems if you enact an ordinance in a way that doesn't give people reasonable, opportunity to participate in the legislative process or in the regulatory process. Kind of more traditional flaws in the process. But when we're talking about land development, it's really the takings clause that is shouldering out the due process clause as a meaningful restriction on governmental regulation.
Okay, I'm going to give folks in the audience, or excuse me, the Ocean City audience, we're going to start the next section at 2:35, but we do have one more question virtually, so I assume that the other folks on there, so I'm going to continue to because we're already behind it, so go ahead and do, but we'll start the next section at 2:35. I have one question here for clarity, Adam. Does zoning fall under a broad legislation of property specific in the case of exactions? So I think your issue about it, you said exactions was parcel specific.
Yeah.
In that respect.
Now, I'll touch upon this when I get into the planning and zoning bit, but that's a good question to tie the two. Zoning is a legislative act. It's broadly applicable, so it would not implicate the exactions principles that I've talked about.
Okay, and the second question here was, and what's the legal litmus test for regulations being rationally related for the public?
Boy, there is no litmus test, and that's part of what makes it so deferential to the government, is because when I say it has to have a rational basis, it's not even necessarily the rational basis that the government articulates in defense of its ordinance. The courts apply a test that says if there's any rational basis, even if the government is not advancing it, the court can still uphold the governmental action. So there is no litmus test or bright line. I think the best bright line there is that unless you are challenging a governmental classification based on a suspect class or a fundamental right, you're going to lose. I mean, that's the only bright line test. I overstate that a little bit. There can be governmental regulations that don't classify on race, but they classify on something else that that might feel like an immutable characteristic. And you get some cases that talk in terms of rational basis with bite, where the courts apply a little bit more of a searching analysis than they do under rational basis. But by and large, it's just incredibly deferential to the government, to leave government room to do planning and zoning and economic regulation. It's really, as long as as long as there's a rational basis, it gets upheld.
Okay, I don't see any more questions from the virtual audience on here. I think I'm going to kind of go back while you're there, and we got a couple of minutes for people to get started. The question before about I think it's important for you to emphasize is the issue of if a regulation is in place and you knew about it, it's you're buying a property with that, and therefore it's difficult to go back and challenge that. I've noticed that particularly in the area of floodplains, where property owners, once the floodplain ordinances are in place, they do limit improvement of properties within floodplains to avoid them overbuilding and or getting essentially more exposing that particular property into more of potential loss in the future. Do you have any insight or observations regarding how floodplain regulations are relate to the issue of some of your, again, observations about constitutionality and
Sure. Yeah, sure. You know, floodplain regulations that are just like flat out prohibitions are going to have a hard time. I mean, they can be successfully challenged as a taking of properties that lie in the floodplain, and you have basically said you can't do anything with it. That's why you see a lot of building regulations and floodplain restrictions talk about elevating a structure to above the 100-year floodplain. So you can build it on stilts or move it back on the property so that it's outside of the floodplain. But that's why those provisions are in there, to allowing people to build beachfront housing on stilts, for example, because if you don't, you're going to have Mr. Lucas coming after you saying, well, if I can't build on my lot, you got to buy it. And the same principles apply when you're talking about riverine floodplains where you're focused on the 100-year floodplain. You have to accommodate people's property rights to some extent.
Great, thank you so much. We're now at 2:35, and let's start on the next section.
Okay.
Thank you, Adam.
All right. So, planning and zoning in Maryland. Now, I'll always start off talking about counties. I know we got municipal folks in the audience today, so I'll just kind of go through this quickly. The state has delegated planning and zoning authority. Joe mentioned that to the counties, to charter and code counties are treated in certain of the statutory provisions. Non-charter counties are in another set of provisions, and Prince George's and Montgomery County are in yet another set of provisions that are set out in your screen. It's kind of complicated how all these fit together because there's some overlap between these different different bulleted groups of laws. And the Maryland Supreme Court has noted that it's kind of difficult to keep all of it straight, but it's what we got. And so when you're at the county level, you've got a lot of what your authority is depends on whether you're a charter or a code county or a non-charter or a commissioner county. Now, this is the same map that Joe showed you that shows the different types of counties. The takeaway is that charter counties and code counties have elected to have home rule, which gives them greater authority to enact local legislation, and conversely, the General Assembly has less authority to enact local legislation in a charter or code county. The non-charter counties, often called commissioner counties, they haven't elected to have home rule, so they have much more limited local powers. Here's a list of the different counties in whether they're charter or code home rule or whether they're commissioner non-home rule. Now let's talk about municipalities. There are 157 incorporated municipalities in Maryland, sprinkled throughout the state, as you can see there, with some notable exceptions. I believe there aren't any municipalities in Howard or Baltimore counties. Municipalities have no independent power unless they are incorporated. So, and all incorporated municipalities have charters and thus all have municipal home rule. So they have a good deal of autonomy, kind of like charter and code counties do, and more so than the commissioner counties do. Now, like charter and code counties, municipalities have the power to legislate on matters of local concern, and the General Assembly, again, is limited in what types of local laws it can enact in a municipality. With respect to planning and zoning, the statutes setting out municipal power can be found at the local government article, sections on your screen, 5203, 5212, 5213, and the land use article, Division 1 of the land use article. Two caveats: that municipal planning and zoning authority applies only within the municipality's boundaries, including areas that are annexed, but they can't plan or zone outside of their boundaries. And also municipalities that are within the jurisdiction of the Maryland National Capital Park and Planning Commission or the Washington Suburban Sanitation Commission can't have planning and zoning ordinances or actions that conflict with those two commissions' measures. All right, so let's break down what planning and zoning in Maryland means. Joe touched upon this. He talked about the comprehensive plan and what it requires, and this is comes with the territory. The state delegates to municipalities local zoning power, but it comes with certain strings attached, that you have to have a comprehensive plan. The local zoning and land use regulations have to be consistent with the comprehensive plan. The comprehensive plan has to include certain planning elements, things like housing and transportation, sensitive areas, and those elements have to implement the state's 12 planning visions, which are listed there on the screen. And basically they are goals, things like sustainable development and protecting sensitive resources. So they're ways that you pursue housing consistent with certain policies that the state wants to advance. So those planning visions have to be incorporated into your comprehensive plan, which again, as Joe said, is the very broadest kind of vision for how the locality is going to develop and redevelop in the next 10 years. The next stage in the process is zoning. So you've got this kind of big picture idea, this big picture plan for how you want to see the jurisdiction develop, and then you enact zoning to show, to delineate the residential areas and the commercial areas that will implement that broad vision that's in the comprehensive plan. And there are a couple requirements that it has to cover a very large area. It doesn't have to cover the whole jurisdiction, but it can't just be a really tiny thing either. It's got to cover a substantial amount of the jurisdiction. It has to be a product of careful study. So you have lots of public meetings. You have the Planning Commission. We'll study it. So a lot of work goes into it, and that I'll explain kind of why in subsequent slides why that's important. And eventually the comprehensive zoning does control or direct all of the uses of the land within the entire, or substantially all of the jurisdiction. But again, we're still at this point talking about a map. It's classifying areas as for different types of zoning. It's not yet property specific. It doesn't impact specific properties immediately. The next step in the process is zoning ordinances. Now, zoning ordinances, they basically set the ground rules by which individual property uses will be determined. And zoning ordinances can permit land uses by right or as a conditional use. Now, land use by right, as this name suggests, if you're in lots in a residentially zoned area, you can build a residence there on your lot by right. Conditional uses are a little bit different. They are uses that are available to the property owner, provided that certain conditions are met, hence the name. They're often referred to as special exceptions, and the two terms are interchangeable. But given that the mechanism for allowing the conditional use is set forth in the ordinance itself, it's kind of a misnomer to refer to it as either a special or an exception, because it's baked into the ordinance itself. But we'll touch upon conditional uses a little bit later. I'm going to stop now for see if there are any questions about the kind of the comprehensive plan, the zoning, and then zoning ordinances before I start moving into some zoning do's and don'ts.
No online, Joe?
Yeah, we have one question so far, at least in here.
I'm going to say up front that this section, there's a decent chance I might ask Joe or Chuck to chime in, because sometimes we get some pretty darn good zoning questions that I can only take so far.
Is there a point at which comprehensive plans go stale? We've been trying for 3 years to update our comprehensive plan, but we seem to be stamping out fires and not being able to get ahead on redoing that. And at some point, does that comprehensive plan just become, if your comprehensive plan is 13 years old, is it still of use and value?
Well, Chuck or Joe can correct me if I'm wrong, but I believe jurisdictions are obligated to redo their comprehensive plan or update it every 10 years. So that's kind of a legislative determination of what they think, what the General Assembly thinks would be a stale comprehensive plan.
Yeah, just I don't know if Joe wants to. So the law requires that local governments review their comprehensive plans every 10 years. Does not necessarily mean that it has to be updated. Just the law requires it to be reviewed. And again, I'll turn this somewhat back to or reframe this issue so it's a legal question. I kind of know the answer, but I'm going to frame it for Adam to respond to it. Is he aware of instances where the zoning is challenged in court and deemed to be invalid because the comprehensive plan has been not updated recently?
Not offhand. I don't. I mean, I'd have to do the research, but I don't know of one offhand. Chuck, do you?
Yeah, no, well, again, it's somewhat rhetorical, but the answer, from my experience, has been no. First of all, comprehensive plans in certain communities don't age, they age well, I should say. Some particularly slow growth communities, they really don't have a lot that's changed. Their local priorities haven't changed. Their land uses, for the most part, haven't changed. So therefore, from a zoning enforcement perspective, the community's character doesn't cause it to be outdated from a comp planning perspective from enforcement. If you go to other states, the case in Pennsylvania, local comprehensive plans are not the guiding principle. It's actually the zoning ordinance, because zoning ordinances tend to get updated much more often there than do the comprehensive plans. But again, generally speaking, if a comp plan is taking a long time to get updated, it doesn't necessarily cause you difficulty in enforcing your zoning regulations in that fashion. I have one more question online that says, how much authority does the legislative body, District Council of Prince George's County have in planning decisions? What if the land use article does not address an authority, but it is a local code? Does local code control?
Boy, that's a very specific question. If the local ordinance falls within the it addresses a matter of local concern, the scope of the district council's authority would be defined by that local ordinance. I don't think there's like a constitutional limit that would apply here. And also the Prince George's County District Council has provisions that are specific to itself, that were enacted by the General Assembly in response to some a controversy several years ago. I don't know, it was maybe 20 years ago, 10, 20 years ago. So the Prince George's County Council, acting as a district council, has different powers than other entities, and I think somewhat fewer powers than other entities in the state. So you'd also have to look at those state laws that place limits on the Prince George's County Council acting when it acts as a district council. I'm not sure I answered that question too well. Chuck, do you have anything to add?
My answer in this one is talk to your municipal attorney in the case of Prince George's County, because the Division 2 of the land use article is very complicated. It requires you to have a very good understanding of things at the local level. So we'll be glad to help you, direct you to your local attorneys and town attorneys, but it's not an area that I think we could easily answer at this point. I'm sorry to say that. Anyone else? Joe, in your group?
Yes, another one. Give me 1 second.
Yeah, thank you. I was wondering if you could explain the difference between density and intensity as far as zoning ordinances are concerned.
Did you all hear that, Chuck and Adam?
Yeah, repeat that again for Adam.
No, explain the difference between density and intensity.
In a zoning ordinance, correct.
Right, that's the question?
Yes, it is.
Yeah.
So I'll give you my answer to that.
Yeah, that's Chuck's going to have a much better answer than I will.
The difference is density is usually a measure of dwelling units per acre. Intensity is typically associated with non-residential uses. It often is associated with a measure of what's called FAR, floor area ratio, and that's a measure for it. But intensity is not as well defined as density. Density is residential density. Intensity typically is involved with non-residential. It could be intensity by measure of what's another measure is impervious surface ratio, ISR. So there's different measures that are often used for intensity, and they are often incorporated into your zoning ordinances to control bulk, massing, and lot coverage issues.
Thank you, Chuck. No more questions in here.
I think you go ahead, Adam.
All right. All right, let's talk about some zoning do's and don'ts. Spot zoning is where you are doing a comprehensive zoning or a rezoning. You've got a residential zone and you put one lot in the middle of it that is zoned commercial. Now, that is illegal if it is inconsistent with the other uses in the rest of the district, and it's done essentially just to benefit the owner of that property. But it's okay if it's consistent with the comprehensive plan and bears a substantial relationship to public welfare. So, it would be legal in a circumstance where there's a need for a service in the residential area for the convenience of the residents who live there, but that's a commercial use. And so you might have a grocery store or something like that zoned in the middle of a residential use for that purpose. So as long as it's consistent with the comprehensive plan and is related to public welfare, it's okay. It's really only a problem when you're trying to accommodate an individual landowner and give him or her kind of more intensive use of the property so they can make more money from it. That's where spot zone, improper spot zoning. Other zoning do's and don'ts. Contract zoning. This is where the land use, the local zoning authority and the owner of property make an agreement, a side agreement about how the land will be zoned. And this is prohibited because it's, it obviously allows for the potential for a special privilege. It disrupts the comprehensive zoning plans are supposed to be, you're painting with a broad brush. It's supposed to cover everything. And so having a kind of side deal with respect to a specific property circumvents that whole process of how local legislative bodies go about enacting comprehensive zoning. Piecemeal zoning. Now, this is something, piecemeal zoning happens after the comprehensive zoning. Spot zoning tends to happen in the comprehensive zoning. You're drawing your boundaries, and you say you zone for an inconsistent use in the middle of the residential use. Piecemeal zoning comes up after the comprehensive zoning ordinance has been enacted, and you can do it under certain circumstances. You have to be able to show that the original zoning decision reflected a mistake that the legislative body made, a mistake of fact, or that there's been a change in the character of the neighborhood. So the example I like to think of is you zone in anticipation of a new highway or a new roadway that's going scheduled to go into or go through the area. And so you put a lot of commercial zoned area around this roadway. And it turns out the roadway at the last minute gets rerouted to someplace else and gets built somewhere else within the jurisdiction. All of a sudden you have those lots that were zoned commercial based on the factually mistaken understanding that they would be alongside a busy roadway, and you have a bunch of property that is zoned residential on the understanding that it wasn't going to be alongside of a busy roadway. So that might be a circumstance where that mistake of fact allows for a rezoning of those specific parcels that are affected by the mistake. The other circumstance is when the legislative body can show that there's been a substantial change in the character of the neighborhood since the original zoning decision was made. And they just didn't anticipate that the area would evolve the way that it was. So you can then, you can establish that, you can rezone parcels of land to accommodate and further that, that kind of change in character. Conditional uses. Now, unlike piecemeal zoning, a conditional use is not a change in zoning because, as I mentioned earlier, the zoning ordinance already allows for the use under certain circumstances. It is allowed if it is, again, it's only allowed under certain conditions. That kind of defines what it means to be a conditional use. It is still compatible with the overall neighborhood and furthers the local comprehensive plan. And it has no adverse, has no unique or different effect on the adjoining properties. And what that means is, when the legislative body says, we're going to provide for a conditional use of, I'm going to have a hard time coming up with something. There's something about a dentist office or something that you can have those in residential areas. They're not that incompatible with residential areas. So you allow for that. But if the person who wants to do that dentist office, if the effect of that, putting a dentist office on that lot is going to have unusual effects on the properties right around it, I'm struggling to come up with a good example of why that would be kind of intuitively obvious. But the idea behind it is that when the legislature provides for a conditional use, it has a certain, it says to itself, well, a dentist office in this area makes sense. There'll be a little bit more traffic, maybe, but it's not, doesn't really change the character of the neighborhood. If for some reason that little bit of extra traffic is going to create a real pinch point in front of this in this area and is going to really affect the lots around it, well, then it may not be an appropriate conditional use. So it all goes back to the fact that conditional uses are baked in to the ordinance from the get-go, and it reflects legislative determination that the impacts associated with that type of use are acceptable within that zone. And if the impacts of a particular type, imposition of that conditional use are different or unusual, then it doesn't fall within the legislative judgment that has previously been made. All right, variances. Now you have to remember that Euclidean zoning is, again, a fairly rigid concept. You're talking about all the lots in here are going to be residential, and then the zoning ordinance comes in, and then you get the regulations come in, and they have some rules about development. But sometimes they interact in a way that maybe you can't build on your property, or the restrictions are too onerous on the exercise of your property rights. Variances are kind of, in that way, a safety valve to avoid unconstitutional takings. There are some limitations. They have to be granted to avoid a hardship, and that hardship has to be due to conditions peculiar to that property, and not to just, well, restrictions on residential lots are always restrictive, and so we're going to give you a variance to build a commercial property, a commercial business on that property. That's not peculiar to the property. That's just the nature of residential classification to begin with. The applicant can't create the hardship him or herself. It has to be created by something else, caused by something else. And it can't be just a way of conferring a special privilege denied to others. And again, this is a theme that you see in spot zoning. That's no good if it's designed to confer a privilege or a benefit on that particular owner. And contract zoning is no good because it's a way for an individual property owner to get a special privilege behind closed doors. And this variance has that same theme to it. So here's an example that might flesh some of this out. You have this existing barn over on the left-hand side of the screen that's located on a large lot, and someone wants to build a proposed residence on the smaller lot next door to the right. Now, that residence has to be built a certain distance away from other structures, the minimum distance separation, or MDS. And that gets calculated that shows how far away from the barn other structures must be built. Well, in order to comply with that MDS distance, you'd have to build the new dwelling a little bit further to the right of that property. It would fit within the property, but it would violate the local setback ordinance. In this circumstance, the property owner could get a variance from the required side yard setback in order to build their house nearer to their property boundary than otherwise would be allowed to. Now, it satisfies the limitations on variance because it's peculiar to the property. It's a result of how this particular house interacts with the barn next door. It's not caused by the person who's trying to build the dwelling house. It's because there's this existing barn there. And a literal enforcement of the setback would result in an unwarranted hardship and perhaps a takings claim here, because they'd not be able to build a house on their residential property. Here's an example of where a variance would be appropriate to accommodate someone's legitimate use of their property rights in a way that allows for a slight violation of local zoning, but again, it's kind of a safety valve to avoid circumstances where people are told that they can't build at all. Right, I promised I was going to talk about vesting, and here we are. Vesting occurs in Maryland. So you're a landowner, you want to develop your property. Your rights vest when you apply for and obtain a building permit, and you start making changes on the property in reliance on that building permit. So maybe you start excavating, or you pour the footers for your building, but you do some kind of work that kind of shows the public that, yeah, you've been granted permission to develop this property. And Maryland, in this respect, is called a late vesting state. Other states might have a rule that just getting the permit vests your right to develop the property. And what it does when your rights vest is it protects you against changes in the law. So if you get your building permit and you start your work on a commercial structure, and then a zoning ordinance is passed that rezones that property as residential, your rights will have vested in the commercial zoning. And the local government, if it tells you, no, you can't build a residential you can't build a commercial property there or a commercial use there, they're going to be, it's going to be a taking. And that's the principal importance of vesting, is that once you've vested, you have the right to move forward with the development of the property, even if the law changes. And vesting is an interesting concept because Maryland takings law pretty much follows federal takings law. So the pronouncements of the Supreme Court about federal takings principles pretty much apply directly to in Maryland law as well. But in the world of vested rights, Maryland gives greater protection to private property owners. So if you can establish that you have vested rights in the development of your property, and the government comes in and shuts you down, the government's going to have to pay for that. Even though under the normal takings rules, you'd look at whether, the Penn Central factors or whether you've been denied all economically viable use. Maryland law is once that you've vested, that's it. Maryland law provides greater protection than does federal law. All right, now I'm about to move into the world of boards of appeals. So let's break here. Chuck, how much time do you need for your presentation?
Well, we're over already, but let's go through these things. And again, we've always said that the legal stuff is the most interesting, particularly to our planning commissioners. So I'm going to go through a couple of questions, and we'll see what Joe's got there. How often do counties revise their entire zoning ordinances, and how many counties have rewritten their codes recently?
That's a Chuck question.
Yeah, counties typically don't do it very often. Prince George's has done recently a complete rewrite of their codes, and then they had a phase in of that. Charles County did a significant change in their zoning a few years ago. When you do large, significant changes, it is very politically challenging. And so typically you do incremental changes to these things. And we're going to talk a little bit later about how you can kind of do certain things through overlay zones and some other tools along the way. Is it common for intensity to be defined by its draw of public facilities or infrastructure? Ideally it is, but intensity also is usually the look and feel of the character. So it's not always infrastructure driven, but it can be useful as a means by which to do good planning. Does the requirement for consistency throughout a district not be hindered by a mixed use? Again, consistency in your comp planning process, if in fact you have mixed use, and in fact there is a specific provision in the state law within PFAs, if you have a mixed use area, you're allowed to actually not be fully consistent with it. And there's a specific provision, and I'll follow up with the Inquirer about that. But there's a specific provision about Maryland's consistency requirements that really allows for mixed uses to actually not have to be purely consistent. If HOA rules conflict with county zoning, this is going to pass this back to Adam. If HOA rules conflict with county zoning, which would the courts uphold in a charter county?
HOA rules conflict with local zoning. I'm trying to figure out what would be an example.
I'll elaborate. To my knowledge, the answer is they don't conflict because HOA is a private covenant that is typically not enforceable. The local government does not enforce HOA rules. So if there's a color of a door, or a paint, or a shrubbery, whatever it is, that's an HOA control issue. It's not a local government issue. It's a civil matter between the HOA and the property owners there. I don't know if you had anything else to say on that.
No, but I mean, if you had like an HOA that said, well, our HOA rules allow you as a lot owner within this development to build a factory and the area is zoned residential, I would think that local, that the county zoning rules would still prohibit the use.
Absolutely, absolutely. Yeah, I'll be honest with you. One of the things that is in place with, and it's going to be a dicier issue, which is the issue of accessory dwelling units. HOAs may not allow those, but the local government might. But again, in that situation, it may be a covenant that you are you basically bought into as a local government, or
Yeah,
as a private owner of that HOA.
Yeah, that's right.
If a permit is granted in violation of an ordinance and the developer starts working, is it a violation? Is the violation vested?
I don't believe so. I think it has to be a validly issued permit.
Right. That would be my say.
Yeah.
Okay, Joe, we're good here.
We have a couple questions in here.
Yeah, you had noted that Maryland is a late vesting state. I was wondering if you could elaborate on what that is a little more and give an example of that.
Well, it's best to compare it with early vesting states. So Maryland requires both a permit and some physical change to the property based on the permit. Other states will say you just need a permit. You don't have to do that second step of actually beginning development under the permit. And some states even, you don't even need a permit, just some sort of government approval or a preliminary plan approval will be enough. Whereas in Maryland, you need to get that building permit and begin work on it. So that's the best way I can describe it. If you take the lifespan of the development, you get like preliminary plan approval, then you get your building permit, then you start work, and then you complete your project. Some states are at one end of the spectrum, others are at the other end of the spectrum, and Maryland is considered a late vesting state.
So is it fair to say then that late vesting is actually more stringent than early vesting?
It makes it harder for property owners to vest. They have to invest more to lock in their development rights, and it makes it easier for Maryland jurisdictions to rezone and change the rules about development with respect to that, in a way that might affect that property, because it takes more for the property owner to get to a place where he or she is protected against that kind of thing.
Thank you, Adam. Your response to that question answered the other question in the room.
Okay. Should I move on?
Yes.
Right. We're going to go a little bit quicker now because the next few slides will, fall into place, I think. We're talking about boards of appeal that hear disputes arising out of zoning matters. They are required for non-charter or commissioner counties and for municipalities. They're authorized in charter and code counties, but all of the charter and code counties have them. The membership of boards of appeals varies according to whether they are established under a charter or non-charter county. Again, you see how in non-charter counties, you and municipalities have less local power when it comes to Board of Appeals. So it's state law that sets out, you got to have at least 3 members, you have to have 3-year terms, and you have to be appointed in a certain way. In charter and code counties, it's how they appoint their boards of appeals, and the size of the boards of appeals is determined by local law. In municipalities, the Board of Appeals can only hear specific types of cases. Appeals when an error is alleged in administrative enforcement or application of local land use law, conditional use special exception cases, and applications for variances. In charter and code counties, they have those same powers, but then they have broader powers. Again, this theme of charter and code counties having adopted home rule, and they can, under their local law, empower their boards of appeals to include review of a whole bunch of other stuff as well. Rules of procedure for boards of appeals is very formal. Have to be publicly announced. They're subject to the Open Meetings Act. Have to be recorded. Witness testimony under oath. It's a lot of court-like requirements. In most cases, the board has to deliberate and vote in open session. You have to record the vote of each member, and you have to actually generate a written opinion based on factual findings and legal conclusions. Again, very formal. It's almost, a lot like appearing before a court. The board's decisions can be appealed. The board's factual findings are given deference, and you see that across the law, that when a fact finder is considered to be closer to the action on the ground, and so when they make certain factual findings, a court sitting in another area, whether it be Annapolis or elsewhere, is going to be loath to second guess those factual findings, but they will second guess the board's conclusions of law. Appeals of Board of Appeals decisions, judicial appeals, are on the record, meaning that you don't get any chance to bring in new testimony or new evidence. It's all as it occurred before the Board of Appeals. Hence, all those rules that I went over earlier about witness testimony being recorded and having written findings, because it all has to be bundled together and brought up to the appellate court so they can see what the facts were before the Board of Appeals. Ex parte communications are prohibited when communicating with respect to boards of appeal members outside of a formal hearing. So you've got a matter pending before the Board of Appeals, and one of the parties comes up to the board member and talks to them about the matter or about something else. If there is such a communication, the board member has to disclose it to all parties and summarize the communication on the record. The idea is to discourage these types of communications as much as possible, but if they happen, you've got to disclose it, because again, everything has to be open and on the record and recorded so that there's not any, kind of backroom deals going on to accommodate, the person who's before the Board of Appeals. All right, that's is the end. We're about to go into the ethics portion.
Go ahead.
I can
Go
stop
ahead.
for questions.
You want to keep on going here, so I'd say.
Okay, I'll keep going then. Okay, some ethics rules. State ethics laws prohibit improprieties and appearances of improprieties. And, as you could imagine, it's designed to ensure fair dealings by officials who hold governmental positions of public trust. people need to know that their public servants are doing right by them. Now, the general provisions article requires that municipalities enact provisions on conflicts of interest, financial disclosure, and lobbying. Those have to be similar to the state ethics laws, but they don't have to be identical. A local municipality's ethics laws can vary from state law in minor ways to account for a local context that is different from the state context, but they have to be fairly minor. Right, here's some examples of specific conflicts of interest that you cannot do. One, hold outside employment that would impair your partiality or independence of judgment. Use prestige of office for private gain. So you're gonna lean on someone in the permitting shop because you're on the planning commission and you give this guy his permit. That's using your status for someone else's private gain. You can't. You have to keep confidential information confidential. You can't use that information and pass it along to someone else so that they can take advantage of it. And you can't participate in a manner in which you have a legal or economic interest. And we have to unpack that a little bit because it has a number of criteria itself. You can't hold or acquire an interest in a business that has a contract with or is regulated with your, your agents, with your agency. You can't be employed on the side by a business that is negotiating or has a contract with your jurisdiction. And you can't represent any party for a contingent fee before any local body. And importantly, this applies to you and your qualifying relatives. That's a term, a statutory term that includes spouses, parents, children, or siblings. So if your sister owns a business that is contracting, that is bidding on a contract with your entity, your local agency, you can't participate in that in any way. Also, restrictions on gifts. You can't accept gifts of more than nominal value from someone who is regulated or somehow doing business with your agency for kind of obvious reasons. And after you've left government employment, you can't act as the paid representative of an entity with respect to a matter that you participated significantly in while employed for government. Now, it doesn't mean if you worked on the contour, defining the contours of a program while with the government, and then you leave government and you represent a developer with respect to how that program is applied to a particular piece of property, that'll be okay. But if you were working on that developer's application and then left government employ and then started representing that developer before the local agency on a matter that you specifically worked on, you can't do that. Recusal, you have to recuse yourself if you have the circumstance I gave where you have a spouse coming up with a project that is subject to the Commission for Site Plan Approval. There, you'd have to recuse yourself. That means you don't participate in any way at all. Disclosure, unlike ex parte communications, disclosure is not enough. You have to completely isolate yourself from the matter. If you have questions about ethics, you can go to the state ethics commissions. The ethics commission, there's their website. They have a lot of helpful information there. I can answer questions too. And Chuck, if there are no questions though, I think I'm gonna skip the test part because we need to get to your part.
Yeah, I agree with you. And I will switch it back to Joe.
All right. So I'm going to go pretty quickly through this. We've already talked quite a bit about comprehensive plans, and Chuck's growth management section at the end always, because it's the end, he always has to zoom through it. So I'm going to take I'm going to go a little bit quicker so Chuck has more time at the end. So we've talked about comprehensive plans. It's one of the key responsibilities of a planning commission, right? And it's the overall vision, organization of, where you want to go with your community. It has to do with the built environment. Public participation is key. Should be transparent, predictable. People reading a comprehensive plan should know the direction that you want to go in your community and how they can get involved. So it's key. So this is one of the major responsibilities of a planning commission that's outlined in the land use article. And the duty is to prepare it, working with staff, working with other stakeholders, experts, perhaps consultants, and then you send it to the Maryland Department of Planning. I'll go a little more in detail later, get our feedback, get feedback of other agencies, and then you would recommend a version for approval to the legislative body in your jurisdiction. 2 of the 12 visions, we saw those earlier. These state code says mandates that these be embodied in comprehensive plans. I know Adam went over them a little bit earlier. So again, a comprehensive plan is a vision. It should have some history as well. How did you evolve, get to where you are now? What are the projections, the numbers showing that you're going to be? You establish your goals, your objectives, and then you establish strategies, actions, decision-making points to help get there. Somebody was asking earlier about a comprehensive plan becoming stale after 10 years. So it's really in the eyes of the beholder and the individual jurisdictions. But one reason why the 10-year has been used as the year that you need to reevaluate your comprehensive plan is because of new decennial census data comes out every 10 years. It gives you a sense of if you're growing or not. But there's also, you can also use American Community Survey, which is also another census product, which comes out in the intervening years. So yeah, a comprehensive plan should look at where you currently are, have something called an existing conditions analysis is pretty common. You have recommendations, how you're gonna get there, but you also need to consider like how, you don't just like create a comp plan and then not look at it again 10 years later, right? You're gonna have to wanna make some changes. You at least open it up to potential changes, amendments over that 10-year period, other ways for people to stay engaged in planning beyond the comprehensive plan. So you need to consider it like a living, growing document. There are required elements of comprehensive plans as outlined in the land use article. You can think of elements as chapters. That's how they are often presented. You have a transportation chapter, you have a housing chapter. They don't have to be. It really means it's element in the pure definition of the term. You need to have an element of your comprehensive plan that addresses various topics. They're different for charter counties versus non-charter counties. I'm not going to go into all the details. And then some are specific. This is MML, so something like municipal growth. That's something that a municipality must include in its comprehensive plan, whereas a county is not going to have to do that. And that would be, municipal growth would be where you envision your community growing, both within its borders, but also beyond its borders in terms of annexations. I'm actually doing a session on annexations tomorrow. If anybody's interested in more in learning about annexations, come by. I'm doing that in partnership with Charles County and La Plata. So here's just some examples of the required elements. Some are very specific, like a fisheries element if you're on tidal waters. Housing element is the newest one. That's the newest requirement. And then there's some permitted elements that you can do but aren't required. So I encourage you to look at the land use article to get a sense of what elements, often again, usually chapters, are required in the comprehensive plan. Yeah, or optional elements. Here are some other ones, as I mentioned, that are permitted. But there's really nothing stopping you from doing another element if you like, but there are certain ones you must do, must include. But I'd say the definition of elements is pretty high level. If you look at the land use article, you have a lot of flexibility within them. There are just certain things you need to consider. So comprehensive planning is definitely not easy. Somebody was mentioned earlier, they've been stuck on the process for 3 years. That's not uncommon. Don't feel bad about yourselves or your jurisdiction. We hear that from everybody. And I'd say that the pandemic definitely slowed down a lot of the comprehensive planning process across the state. People are we always talk about trying to reach consensus in planning. That's really hard to do, if not impossible. You're gonna have people that have disagreements. So you have to wrestle different viewpoints. You know, the desire to protect the rural landscape, but then people that own that land, they have property rights. You know, we were talking earlier with takings, and there's a lot of different things you have to wrestle with. The need for more housing, affordable housing, but the concern, I'm sure many of you are familiar with, the concern for more density or growth in a community. Right? These are things that are difficult. There's no easy answers there, so it can be challenging. But you want to make sure the best way is to engage a large number of folks. It's not, you know, you always have the same people showing up at public hearings often, but there's a lot of people in your community who might not be coming to those public hearings on a development proposal. But you engage them early, and often in the comprehensive planning process, you can get a broad perspective on your community and the desires, and you can get, you know, you just have a better plan that more people buy into, the more people you can engage. So here's examples of the stakeholder groups you definitely want to include. You have advisory groups, you can do surveys. There's all sorts of ways to engage your community, but it's one of these essential building blocks of any comprehensive plan. So work sessions, something we're going to talk a little, I have another slide on those later, but these are very important. Work sessions are where a planning commission can really dig in with staff, if you have consultants or other experts on the issues facing your community. You could have background studies, you could analyze surveys. So work sessions, while they're available and open to the public, usually not where you're taking public testimony. You know, that'd be something separate. I would recommend doing public meetings where the planning commission or staff is going out to different sections of your community where you could have more public input. It's important to note that comprehensive plans aren't a standalone document. They need to be coordinated with other planning things you do and other documents you have. And there's requirements in state law for the consistency between a comprehensive plan and other plans. So municipal growth, if you want to annex, your municipal growth element needs to be consistent with where you want to annex. School planning, right? If you, there's these things called educational facility master plans. Usually they're at the county level, but they should be consistent with comprehensive plans. Water resource planning. The counties have water and sewer plans. We review them in the Maryland Department of Planning. If they want to amend or change a water and sewer plan to say we want to serve this area with sewer, well, the comprehensive plan needs to make it, that it needs to be consistent. The comprehensive plan needs to say this is an area we want to serve with sewer. So it's an infrastructure aspect, just like transportation planning. Counties submit priority letters to MDOT every year, asking for capital funding to be included in the state transportation plan, the CTP for that year. Well, we looked at that to see if it's consistent as well. So it's important to keep that in mind when you're developing a comprehensive plan, that there's a lot of other things that it influences and it should be consistent with. And there is a definition of consistency in the land use article. It's important to coordinate with your neighboring jurisdictions on comprehensive plans, especially municipalities with counties. You know, if you want to annex certain areas, you want to grow into certain areas, I mean, the county should know about that. Oftentimes they're going to be helping to provide the infrastructure to support that growth. So it's very, very important to coordinate with your neighbors on your comprehensive planning process. And you have to send them your draft comprehensive plan, just like you send it to the Maryland Department of Planning. So the earlier you can do it, the better, right? You'll be able to iron out some difficulties or differences the earlier you send it to them, rather than they get it right at the end and they're surprised. So the draft is developed by the Planning Commission. There's a 60-day public notice and it's sent to the Maryland Department of Planning. We send it out to other agencies and you send it to your neighbors. And then we will send back comments within 60 days. And then those comments become part of the record for that public hearing of the Planning Commission. You can have multiple public hearings, but you need to have at least one. And then you can recommend it for adoption to the legislative body who has the final authority. And they can modify it and send it back to you, back to the Planning Commission. The Planning Commission is the main driver here. And then, as we mentioned earlier, it's required to review every 10 years, not necessarily change every 10 years, but you do need to review it every 10 years. Maryland Department of Planning and other agencies have developed a lot of resources to help with comprehensive planning. I have my cards around here somewhere. I know somebody got them. Somebody's passing out my cards because somebody had one earlier. There we go. My division, the local assistance and training, is the one most focused on comprehensive plan assistance, but we have our whole department will help anything from demographics to water resource planning. and then a lot of other agencies as well. So I don't think you're alone. Any questions about comprehensive plans? Yeah.
Hey, Joe, just real quick, just to want to emphasize one thing. Recent law was changed, so municipalities need to realize this, particularly municipalities and non-charter, that the legislative body can amend your recommended plan after holding a public hearing. They could choose to change what you thought you were the best things in their plan for whatever reason, and they could change it without having to come back to you. That's why it's important for you to have incremental and check-ins with your legislative body so that you don't have a situation where they throw out your most important pieces because they didn't really agree with you after holding the public hearing. They changed what you submitted them. So just be aware that you, whatever you recommend can get changed by the legislative body after a hearing.
Thank you.
No comment, no comments here. Questions here.
We got one question here.
That was my question.
Chuck is he's answered a few questions today that were preemptive to the questions in the room. So thank you. All right, I'm going to continue to the next topic. All right, Planning Commission roles and responsibilities. So you're a part of a much larger team. One thing I forgot to mention, Board of Appeals. Board of Appeals, I don't know how many members in here are Board of Appeals members. Okay. They might not have as much of, even they should be consulted. Not always are Board of Appeals going to have as much of an active role in the development of a comprehensive plan, but they definitely play a role in the implementation of it. But I would always recommend that they be included as part of the comprehensive planning team as well. But it's not as clearly articulated in the land use article what their role is. So there's a lot of people involved in your work. So I want to stress to the role of the Planning Commission, while some of it's outlined in state code, a lot of it is defined locally. So look at your code, look at your provisions, look at your rules and procedures, and that'll give you a lot of insight into what you actually can and can't do. Let me start. All right. So again, as we mentioned, crafting the comprehensive plan is one of the main things that any planning commission will do, but also part of that implementation. You can recommend ordinances and regulations. You look at zoning, make recommendations on zoning, subdivision, and then apply those tools. All right. Kind of already, we went through the comprehensive plan ad nauseum, I think, so I'm going to keep moving there. So in non-charter counties and municipalities, which we're here at MML, so we're talking about municipalities, you do play an advisory role with zoning ordinances, those other land development regulations I mentioned, capital expenditures and other implementation tools as well, such as land preservation, annexations, development rights and responsibilities and agreements. There's some areas in which the Planning Commission have approval authority. These areas include approval, use of public land, such as public streets, parks, and other public purposes. You have the authority to review and approve some types of development, such as minor subdivisions, if those are delegated in your authorizing provisions. So this is one of those situations where make sure you look at your own provisions and code, because some things have been delegated to the Planning Commission while others have not. And this is, no, sorry. It's different in charter counties. In some, their provisions are defined by what their charters say. We have no charter counties here since we're at MML, but that can give them the authority to approve rezonings, special exceptions, and variances, as Adam discussed. But you would find that in the actual charter of the county. So we were talking about work sessions earlier when it comes to the comprehensive plan. You can obviously use work sessions for other items as well. This is a situation where the Planning Commission is going to dig deep into an issue and have that more engaged back and forth with staff, people, consultants that may have done studies, even with a county or other stakeholders. But it doesn't always, or usually doesn't have an opportunity for public comment. If you haven't developed them yet, I definitely recommend rules of procedures for your Planning Commission. The Maryland Planning Commissioners Association, which I support, has a website with some examples on there. I know the Maryland Department of Planning has helped some municipalities develop their own rules and procedures. So I would definitely recommend considering those and reviewing them if you have them. All right. So in some instances, you might have a site plan approval. As an example of a site plan, they'll have the layout of roads, a tabular data describing the site, relation of different land uses. So to definitely get understanding of how to read site plans. It's important to note that staff play a crucial role in the preparation for work sessions or public hearings, right? They need to provide ample time for the staff reports and site plans. Things need to be presented to the planning commission. I mean, being a planning commissioner does involve homework. I think we all know that, but that's something to make sure you coordinate with staff. You get that support and enough time to be prepared. It's very important to be prepared for those meetings. All right, the septics law. All right, I'm going to definitely rely on my notes here. This is my last slide because this is not my area of expertise, but this is a 2012 law which basically require jurisdictions to decide where they're going to allow major subdivisions on either septic or on sewer. So there's 4 tiers. Tier 3 is where the PC review, planning commission review comes in. And those are areas for major subdivisions on septic. All right, so the planning commission has a review role on major subdivisions on septic. So you'll make a recommendation for approval on those. So if you have, not every single jurisdiction in the state adopted a tier map. If they didn't, that means you can't approve those major subdivisions on septic. But if you did, make sure you review yours where they are because they're definitely specific requirements. And tiers 1 and 2 would be where it'd be on sewer as opposed to septic.
So the septic law, the provision that requires the planning commission to review tier 3 plans for consistency with the comp plan and consideration of community character, that typically is in the counties and not in the municipalities. And the reason is in certain counties, the delegation of authority of approving the subdivision is actually to staff or a specific person that reviews and approves those. So again, the tier 3 review by a planning commission, again, typically is associated with the county. So we're going to do lightning round here in the last 10 minutes here to get you out on time or as close to as possible. This is where the rubber hits the road at the local level, and this is where you turn your comp plans into reality. So these are the growth management tools and a variety of other things that we have. Next slide. So zoning is your most powerful tool. And in fact, there's a recent report from National Center for Smart Growth, and they cite that zoning is their #1 priority tool. It controls the use of properties. There's usually a map and a text. Density, intensity, form are things that are covered in that. Next slide. So again, this is the typical map. You color code it in those areas. You think about what's adjacent and across the street. When you do your zoning map amendments, I always encourage locals to make sure you think about what's across the street, because the like uses are often right in front of you. So you typically will see property zoning boundary changes at the rear property lines along theirs. And so just be mindful of when you're doing your zoning maps, what the adjacent uses are, and are they different, or when do they change? Next slide. So again, as Adam talked before about Euclidean zoning, so that's the traditional where you define your full array of land uses into different categories of zoning. So residential, or different densities of residential, or commercial, different densities and intensities of commercial, industrial. And then you have mixed use. Mixed use is actually not new. I'm talking to you from Frederick, Maryland right now. And Frederick has a wonderful downtown that predated any zoning. And it's why it's so wonderful, because it is mixed use. And we kind of we've recognized and come back to recognition that mixed use is an important component of quality communities. And Maryland has wonderful towns all over the state, and you'll see that those are mixed uses. Next slide. So as I alluded to before, sometimes you can, instead of doing a comprehensive rezoning, you can do an overlay zone, and you can try to address a particular interest or concern using an overlay zone. Overlay zones are often used for historic districts. You can do one along a trail or along a waterfront or a particular type of activity. It can change the types of permitted uses, but it also could add additional requirements on the review process. So overlay zones are a very useful and powerful tool that don't upset the apple cart and don't throw everything out, but allow you to actually influence where you want changes to occur. And again, they have to be really consistent with your comp plan. So that's the first thing. Next slide. So one of the newer forms of zoning out there is called form-based zoning. And what it does is it allows you to regulate the shape or the look particularly from the public right of way. So you look at the uses and you have less concern on the range of uses within those buildings, and you focus on what the form is, because that will often control what the intended use is. And so it's a new approach. It tends to be very, quite frankly, a little bit more complex. And so if there is interest in that, David Dahlstrom in our office has been trained in form-based codes, and we will be glad to provide technical assistance to your community if you're interested in pursuing that. But it's not, it takes time. Next slide. So the other next powerful tool that you have in your toolbox of land use controls is subdivision. Municipalities typically have, but for if you don't have the zoning planning authority, typically planning commissions often will approve subdivisions. Again, subdivision is the consolidation or the division of land into two or more lots. And along with subdivision, next slide, are the things that control the public rights of way. So how wide is the street? And again, this ties back to your comp plan. What kind of character do you want your streets to look like? Typically, you include in those rights of way utilities, landscaping. All of those things are often spelled out in specifications. And if a developer is coming in and wanting a new subdivision approved, those improvements are typically required of the developer. They often are bonded and inspected at the local level before they are transferred over to the local jurisdiction to maintain from that point forward. Next slide. So as Joe talked about the issue of water and sewer planning, that is a very powerful tool to control the progression of your development, so that you don't leapfrog and miss areas, so that through the water and sewer plan, you can incrementally expand and serve your communities. They're required to be updated every 3 years, but they really can provide an important growth management tool. Often you have adequate public ordinances, which is we'll be talking in a second, that are often associated with capital improvement planning like this. Next slide. So water and sewer planning, again, you need to do the typical comp plan process. You look at your development review process, you inventory things, you look at the service areas, and you address the need for expansions or upgrades of facilities. Next slide. So you want to figure out where you're going to serve, look at the comprehensive planning process, and you need to be realistic about how large of a service area can you have? Can you really accommodate? Because once you extend those areas, you need customers to actually pay for the maintenance of those areas. And you also want to recognize that uses require different amounts of water and sewer service. So heavy industrial uses will require a lot more than commercial areas, which often can be less than residential. Next slide. So I mentioned before, adequate public facilities. There are 13 counties and 23 municipalities that are currently using these. Schools is the #1 controlled or regulated infrastructure or looked at infrastructure. And the APFOs are intended to be a growth management tool. They are not intended to shut down development. They're directly related to capital improvements programming. And if you use an APFO to just shut down development, ultimately you will lose in court, because there's an expectation that the hold or the delay in development is occurring because you are getting the necessary infrastructure in place. APFOs also mean that you're planning and you're committing to capital investments so that you are, again, not going to create unnecessary delays in the development process. Next slide. Again, any jurisdiction can adopt them. Development approvals contingent upon whether the service is there, so you need to be really specific on levels of service, and those levels of service should be debated and talked about at the local level, and everyone should know that, hey, we want a lower level of service, say in our downtown, and we're okay with some more congestion and slower speeds because we want it to be more pedestrian friendly. So a lot of jurisdictions often will exempt out their downtowns from APFOs, or they'll accept a lower level service because they don't want high speed, or they don't want to force development to create high speeds and wide roads in an area that is more pedestrian oriented. So again, standards are critical to this process, and if you don't have standards, you're going to lose in court. Next slide. We do have a reporting requirement as part of the Department of Planning's and part of the annual reporting process, particularly every 2 years. Jurisdictions that adopt APFOs are supposed to submit a report to us on the types of restrictions of development that have occurred, and then we report those back to the state, to the General Assembly. Next slide. I'm not seeing any questions here. Moving on, I'm going to move on here. So we're going to talk about, these are the, I'll call non-regulatory components. Well, this is another part of your toolbox. So capital improvements programming, again, local governments approve capital improvements, capital plan budgets. A lot of small jurisdictions don't have capital budgets. If you're got a little bit, if you're a little wealthier, you sometimes do have those, and it's always good to have those because, again, you could tie your APFOs to your investment. Next slide. So there's a whole range of funding sources that are typically associated with the capital improvements program. General funding, obviously, basically your property taxes. But and you can do some bonding. If you're a larger jurisdiction, you have community development block grant funding. That's a revenue source. Counties typically have pretty much a predictable revenue stream from POS funding, water and sewer, obviously, and sometimes state aid. But again, typically your capital improvements program usually want to have it associated with a predictable revenue stream. Next slide. So the process for capital improvements is just the same as a comp plan. You do an inventory, you analyze it, you evaluate what your capital improvements are, you prioritize projects, and you implement them. Next slide. So Joe talked about this already, about the annexation process, but annexations are a very powerful tool for municipalities. I don't need to tell you guys already at MML that, but in fact, it's a part of the process that you should incorporate that in your comp plan, or required to, as municipal growth element, and you factor in the infrastructure demands for that future annexed area into your comp planning process. Next slide. So there are obviously some contingency requirements for any annexation. It's got to be contiguous to a jurisdiction. Go figure. You can't annex something that's already in another municipality, and you can't create an enclave. Maryland has a very liberal enclave definition. As long as there is an umbilical cord of county land that is not annexed, you can do a serpentine arrangement. Always consult your attorney, town attorney. There have been some court cases and there's some debate about what's considered a compact area. But I have seen, I know Frederick, for example, some portions of it, they use the railroad right away as the connection to a piece of unincorporated area, almost fully surrounded, but not completely surrounded by the city. So just an FYI, don't create enclaves or else you will, if someone challenges it, you'll lose. So just FYI. Next, municipalities. Again, there are opportunities when you do an annexation. Again, you should probably lay this out in some of your comp plan. You can prohibit certain development activity in a certain area as part of the conditions of approval. There's usually an annexation agreement associated with the annexation adoption resolution, so that you, if you want to, this is the one time municipalities, again, you hold the cards. Once they're annexed, they got to be treated like everyone else, but you don't have to annex a piece of property. And if someone wants to be annexed because they want water and sewer service or some of the other reason they're knocking at the door, you have a chance to negotiate that annexation. Next slide. So there's another type of agreement that's out there. It's called a development rights and responsibility agreement. It's essentially, it's not contract zoning, but it does give the ability for a quid pro quo. And what it does is it freezes the regulations in place with an understanding that the developer of the property is doing certain things that are in the public benefit to the community. There's lots of legal issues associated with this, so always have your town attorney involved in it, but it does enable you to have some expectations, and often these are associated with master plan communities, and where they're going to be developing it over an extended period of time, and they want some assurances that the rules aren't going to change halfway through the development. So this is, again, addresses somewhat of the vesting issue at the same time. So if in fact there's a 1,000-unit development right next to the to be annexed into your town, not only you can develop an annexation agreement, you can have a development rights and responsibility agreement in place. And what it allows them to do is the developer has some assurances that you're not going to change the rules halfway through, or at least during the agreement period. Next slide. So we have a bunch of other tools. The Department of Planning has a lot of tools. Our MML is an excellent resource. MACO is an excellent resource. We also have a Smart Growth Information Clearinghouse. We have trainings. I'm going to give a shout out again to the MPCA. They have a lot of training opportunities, and Joe works with MPCA very closely, so it's a great opportunity to do hands-on learning if there are instances. Again, talk to Joe or the regional planner. Next slide. Okay, we can go through these real quick. Zoning can be changed through comprehensive process or a piecemeal, mostly the comprehensive process. Subdivision is, again, A, all the above, or D, all the above. Next. Water and sewer plants, B, every 3 years. Next, capital improvements, all the above. These are all the things that, unless amended, extended. This is the only thing I didn't mention before. The development rights and responsibility agreements last 5 years. They have been extended in certain jurisdictions more than that, but it's got to be a mutual agreement. And so just an FYI, which of the following is true about newly annexed areas? Again, all the above. And finally, let's go to closing. I'm getting close. I'm only 5 minutes over. One more. Do you have any more in there closing there?
Do we have any questions or
Oh,
any
yeah.
statements?
No,
We
no,
do have,
no questions online. Anyone, any questions from the folks there?
we have one, Chuck. Give me a second.
Sure.
Yeah, regarding Board of Appeals, is it normal for variance applications to skirt a planning and zoning commission and go straight to a Board of Appeals?
Yes. In fact, it's actually, and again, I don't know if Adam still is on the line. I actually don't recommend the planning commission weigh in on those, but it depends upon how your ordinance is written. Because I have seen situations. First of all, the Board of Appeals can be called on to if there's a challenge of an administrative action. There are instances where the Board of Appeals will rule on the actions of the Planning Commission. I've seen that, or the zoning and hearing officer or zoning administrator officer. Usually, again, I think it gets dicey. As a general planner's experience, I recommend that the Planning Commission stay out of the Board of Zoning Appeals hair, because it's a quasi judicial branch, and it just gets more, how should I say it, political when the Planning Commission weighs in on this stuff, and it's almost like ganging up on the Board of Appeals. Treat them like the step before you go to the courts. And so, as a general rule, I recommend against it. But again, your local ordinance may actually allow for it. I'm not sure I think it's a good idea.
No more in here, Chuck. I don't know if there are any online.
None online. So we're going to go to closing. So again, thank you all for participating online and in person. A big shout out to Joe and Keith being there, putting everything together. We had great support from John Coleman and Greg Schuster at Maryland Department of Planning. Thank you, Adam, for joining us. I know you had some circumstances that you would have been there. We want to thank everyone for attending. Again, thank you so much for your service. We will be, I just noticed this is an old slide, and I got to get it updated. Got a new administration, so I got a new secretary, so we will get a new certificate ready for you. So look to see that within about maybe up to 2 weeks. Hopefully we'll send them out to you. Like I said, suitable framing, and we will include a link to the PowerPoint presentation. If there are any follow-up questions you have, feel free to talk to Joe there in office, or you can email me. Again, my email is chuck.boyd, B-O-Y-D, @maryland.gov. And we'll be happy to respond to your questions. And again, I want to thank you for the time today. And for those in Ocean City, hopefully the weather will accommodate you, but have a great time at MML. And thank you very much. And I think we're done now.
Chuck, I have a couple quick things. Thank
Sure.
you, everybody. I just want to say, Chuck's mentioned the Maryland Planning Commissioners Association a few times. I'm the primary staff to that. If you're interested in continuing your education as a planning commissioner and board of appeals members, I encourage you to check out that organization. I'll say we have a couple events coming up. We're having a Western Maryland regional workshop on July 19th in Frostburg, 1 to 4 p.m. at the City Place, the building called City Place in Frostburg. If you're out west and you're interested in attending, then the Maryland Planning Commissioner Association has its annual conference at the Kent Island Resort, October 24th through 6th or 25th through 7th. I'm forgetting right now. We have it on our website. A 3-day conference is the 40th year of the MPCA, so it's a 40th annual conference, and they're doing it up big. So a very affordable conference compared to a lot of them. So I encourage you to consider attending that. So thank you all very much. And grab my card and make sure you signed in if you didn't sign in yet. Thank you. And I'm glad we had such a great turnout here today.
Thank you all, and we're going to be ending the webinar right now.